Good morning, everyone. My name is Teresa Crisanti, and I'm with the Illinois Restaurant Association. I'd like to thank you for joining today's webinar, State Legal, Here Labor and Employment Law Updates. During today's webinar, we'll hear from experts at Lanner Muchin Employment Law Firm. Today's webinar is being broadcast in English, Spanish, and Mandarin Chinese. To listen in Spanish or Chinese, please use the interpretation button in your toolbar. This webinar is being presented by the Illinois Restaurant Association in partnership with the Cook County Small Business Source. Established to ensure businesses emerge from COVID-19 intact and positioned for growth, the Small Business Source connects small business owners with expert guidance and support. Services include no-cost business advising, resources, and events that connect small business owners with a community of advisors. For one-on-one business advising, sign up at cookcountysmallbiz.org. It's free and signing up is easy. Also, before we begin, I'd like everyone attending to know that the Illinois Restaurant Association remains a resource to you as the hospitality industry continues efforts to recover. Our staff is focused on providing guidance, assistance, and relief to restaurants, bars, caterers, and other hospitality businesses in Illinois as we all work to operate and emerge fully again. We send regular email updates to thousands of operators around the state with what you need to know for your business, and you can sign up for those on our website. For today's webinar, you can use the Q&A button in your toolbar to post your questions at any time during the presentation. At this time, I'd like to introduce our panelists. With us today is Robert Bernstein, partner at Lanner Muchin Employment Law Firm. Rob, thank you so much for being here today, and I will turn the floor over to you.
Thank you, Teresa. I appreciate it. And you know by now, over all these years, how much I am glad and enjoy partnering with the IRA and, delivering these educational seminars to remind people of the, it's been an interesting time frame more than ever. I mean, over the last years, there's been more and more complexities in terms of the number of laws that have come down the pike and the need for restaurants and other businesses to make sure that from a compliance standpoint that they understand these laws and are doing the right things as it relates to them. So thank you very much for putting this together. Glad to be here. We do have a good amount of material that I'd like to at least touch on to help the members and other guests on this webinar at least issue spot to start. And as I always say, and I'm going to say it here, look, we don't have that much time together, and there's a lot of laws and different things that I'm going to be talking about. So, you have my contact information. If you have any questions as a follow-up, feel free to email me, feel free to call me. This can be a continuing dialogue. I do want to make sure that the IRA's members are compliant and that they're, doing smart things in this area to protect their businesses. So with that said, let's jump right in. The topic here is 2023 employment law update. I'm going to hit on a lot of the more notable laws and developments that have taken place. Of course, there's other ones, and I'm even going to mention a few more that aren't in the slides. But these are going to be a good start for you, and hopefully you're already aware of many of the things that we're going to be talking about. But it's a good refresher. All right, so let's start. Let's go to the first slide.
Rob, I know Brittany, our colleague here, is just having a little bit of technical problems, so the slides are lagging a bit. So if you just want to go on with your presentation, and we'll figure it out, okay?
Sure. Keep going to the next slide. No problem at all. So one thing I wanted to mention is that from a federal law standpoint, and let me be clear, when I say federal law, that pertains to any restaurant or business in any of the states in the United States. Okay, so when I say federal, as compared to some of the laws we're going to talk about are Illinois-based, Cook County-based, Chicago-based, this is a federal law case. And this case, you may have heard about it through different things you've seen, but it was a National Labor Relations Board decision that came out in February of this year. A very important decision. You may be thinking, you may be scratching your head, like, God, the restaurant world, there's barely any unionization that goes on, and there's not many places that are unionized. And, I thought that the National Labor Relations Board and the National Labor Relations Act only applies to union settings. and you can tell by the way I'm saying that's not the case. Okay, the National Labor Relations Act and the National Labor Relations Board has jurisdiction over non-union employers as well, like the folks on this phone that have non-union restaurants, okay, and other businesses. And this is important because to the extent that you are a business that at different times offer severance agreements to a departing employee, whether or not you've terminated them or whether or not they've resigned and you've agreed to some form of severance payment. This case is very important in terms of the terms of those severance agreements as it relates to, in large part, non-disparagement and confidentiality provisions, which are typically always part of these types of agreements. And just to be clear, non-disparagement is a provision which says that the employee can't talk bad about the restaurant or any of its managers or owners. And the confidentiality provision is a provision that says that the person needs to keep the terms and conditions of the settlement agreement and the circumstances leading up to their departure confidential. Okay. So what this case did, let's go to the next slide. And by the way, this case applies to non-supervisory and non-management employees. If you have a management or a supervisor, this case is not pertinent to those individuals. But you keep in mind that you have to make sure that they're a manager or supervisor as defined under the NLRA. But basically, in summary, what this case said is that you can't have the extremely broad confidentiality and non-disparagement provisions that we would see, in many of these agreements for non-supervisory employees. Okay, so if you have language, for example, let's start with confidentiality, that says that you can't disclose the agreement to any third person, or that you can't talk about any of the circumstances leading to your departure. Okay, that's going to be way too broad. Okay, it's questionable now whether or not you can even limit it to the financial monies being paid under the agreement. That's even aggressive under this case. Okay. As to non-disparagement, what you want to have now is you no longer want to have non-disparagement provisions if you're going to comply with this McLaren-Macomb. And I'm going to come back to that in a minute, that point, the practical point. Okay. So to comply with this McLaren-Macomb case, you want to word things in the agreement in terms of non-defamation and employees not being able to make maliciously false defamatory statements as opposed to non-disparagement, the much broader term. Okay. Now, practically speaking, you as restaurants, okay, have a decision to make, and that's that being, are you going to go to all lengths to comply with McLaren-Macomb in the event that this document gets before the National Labor Relations Board, if the person goes to file a claim? Or are you more concerned about protecting the business through, a non-disparagement and confidentiality provision that's broader? And are you willing to take more of a risk because you don't think that the likelihood of it getting before the National Labor Relations Board is great? You could tell from my comments that I'm having these conversations with clients all the time. There's no cookie cutter size formula. There's no one size fits all right answer. All I'm telling you is that if the document did get before the National Labor Relations Board, a severance agreement, and you had overbroad non-disparagement and confidentiality provisions, it could conceivably impact the enforceability of the agreement, conceivably. And at a minimum, the National Labor Relations Board would not be happy about it, and it could lead to a claim against your business. So talk to your, HR people, talk to your labor and employment counsel. If you haven't looked at, if you're a larger restaurant group that more frequently uses severance agreements, I'm assuming, and I shouldn't assume, but I'm hoping, I guess is the better word, that you've already worked with counsel to make these decisions as to what language is most appropriate and you feel most comfortable with. But if you haven't done so, feel free to ask me any questions. Feel free to you should talk to your Labor and Employment Council. But I'll end with saying, at a minimum, in light of this decision, as it relates to non-supervisory employees, you at least have to be mindful of this case, unless you're just going to go in taking the full-blown risk. Let's go to the next slide. Federal COVID-19 national emergency and public health emergency declarations ended on May 11th of this year. Just want to remind people, okay, this is old news, but on January 30, 2023, the Biden administration announced that it will end both the COVID-19 national emergency and public health emergency declarations that ended on 5/11/23 this year. And the impact is in two major areas as it relates to group health plans. To the extent that you have group health plans, under which certain of your employees are covered, all COVID-19 outbreak period relief applicable to group health plans will end as of July 10 of this year. So about a month ago, it ended, okay? Deadlines and grace periods under group health plans will no longer be extended per the COVID-19 outbreak period, and you'll revert to their standard timing. And then also on 5/11/23, the federal requirements for COVID-19 pandemic-related coverage under group health plans will expire, including coverage of COVID-19 diagnostic testing and related services, COVID-19 vaccines and boosters from out-of-network providers, and standalone telehealth benefits and other remote care services for patients who are not eligible for major medical coverage. So I just wanted to flag, again, this is somewhat of more recent old news because these things ended on May 11th of 23. But for those groups, like I said, that have group health plans where people are covered, just wanted to have this on your radar to the extent that it wasn't already. Let's go to the next slide. This is important as it relates to employment verification, the temporary relaxing of employment eligibility verification, I-9 compliance rules, which are required for all your employees at the beginning of their employment, where they required in-person verification. Okay, so the temporary relaxing of the in-person verification requirement, which was in place through the pandemic, obviously because of the circumstances, that has expired as of recent, as of the end of July. So, a few weeks ago, you need to go back to the in-person verification. Okay, employees onboarded on or after April 21, whose I-9s were completed without physical inspection of their documents, now must have their documents inspected in person. This means that employers must complete this physical inspection for all employees who did not previously receive it by no later than 3 days following the expiration of the temporary change to the I-9 rules, which already took place. So that needed to be done. This is just really a reminder that to the extent that you haven't done that, you want to be on top of this immigration I-9 related requirement now. If you have any questions about this, please ask me. I know that we've been making sure that our clients are on top of this and making sure from a compliance standpoint that they're well aware of this. Let's go to the next slide. Okay, so now I want to talk about Illinois updates. Those things we were just talking about were federal, okay? As I said, they pertain to all restaurants and other employers, throughout the United States, domestically here, okay? Now I want to focus on some key Illinois labor and employment legal updates. Let's turn the slide, please. And the first one is that the Family Bereavement Leave Act amended the Child Bereavement Leave Act. This is an Illinois law, effective January 1 of this year. This is a reminder. Okay, it's been in effect for about 8 months now. But employees eligible for FMLA may take Family Bereavement Leave Act leave. Okay, so as a reminder, the FMLA, the federal FMLA, that's been around since 1993. So if you can believe it, about 30 years now. And that pertains to businesses or employers that have 50 or more, 50 or more employees within a 75-mile radius. Okay, so if you're not covered by the FMLA, have any employees who are covered by the FMLA, the the threshold requirement is that the FBLA leave is there for employees who are eligible for FMLA, so it wouldn't be pertinent to you, okay? Also, to be eligible as an employee for FMLA, you need to have worked 1,250 hours within the prior year, the rolling 12-month period typically, right before the leave request. So if, as we see here, it's in this box here, if you haven't done that, you're not eligible for FMLA either, and then the FBLA requirement wouldn't be present there for you either. But what is the family, I'm going to just call it FBLA, what does that do? It really does a couple major things. It provides 10 days of unpaid bereavement leave to attend the funeral or alternative to a funeral of a covered family member, to make arrangements necessitated by the death of a covered family member, or grieve the death of a covered family member, and 6 weeks if employee loses more than one covered family member within a 12-month period, okay? Covered family member has been expanded. You can see the definition there. And employees now may also, under the FBLA, take 10 days of unpaid bereavement leave due to a miscarriage, an unsuccessful round of intrauterine insemination, a failed adoption match, a failed surrogacy agreement, diagnosis that negatively impacts pregnancy or fertility, or a stillbirth. So 10 days of unpaid bereavement leave, I'm going to summarize, to cover different unfortunate events related to pregnancy type situations. That's also now under the FBLA. Okay, next slide, please. The Crown Act was an Illinois amendment. Crown stands for Creating a Respectful and Open Workplace for Natural Hair. There's an amendment to the Illinois Human Rights Act to specify prohibited discrimination on the basis of race includes discrimination based on traits associated with race, and that provides that race includes traits historically associated with race, including but not limited to hair texture and protective hairstyles such as braids, locks, and twists. So what does this mean practically for our restaurants and other hospitality related clients and other businesses? Please do me a favor and do yourself a favor and check in your employee handbook your dress and appearance code policies to ensure compliance with this Crown Act. Okay, we've been amending and updating our clients' employee handbooks at length because there's been so many new laws, and this is just one area where we've had to modify certain policies in these handbooks. Okay, and I digress just to the broader point. It's so important. I want to emphasize it. I get it. Believe me, I'm assuming, and I haven't seen the list who's on this webinar, but I'm assuming that it's restaurants and related businesses of all size and all different resources. And I get it that, if you're a smaller restaurant, you don't have the resources, that you may not have had someone look at your employee handbook for a while, or sometimes you may not even have an employee handbook, and it's no knock on you as a person. It's just that resources are tight, and you're trying to operate your business in such a manner. But I'm just going to leave you with, on this point, I could tell you so many different stories that would support the fact that you really need and should have an employee handbook, and you should have an updated employee handbook. In the scheme of things, it's not that costly, and it's a very protective document to your business. You want to have your employees sign off on it. If you have people who speak, for example, Spanish as their first language, or whatever language it is, you really want to have it translated so that they understand it. So I urge you strongly that if you haven't had your handbook looked at in a while, or if you don't have a handbook, please talk to someone that could help you, get that in place. Okay. So I'll leave you with that on that point. Let's go to the next slide. We've all heard about this. I'm assuming this has been such a big piece of news, which is the Illinois Paid Leave for All Workers Act. This is going into effect on January 1 of 2024. On March 13th of 23, Governor Pritzker signed the Paid Leave for All Workers Act into law, and this act provides paid leave for nearly all employees. It provides 40 hours of paid leave for any reason, effective January 1, 2024. I want to get out of the way. You may be wondering, at least as of now, and I want to emphasize at least as of now, stay tuned because there could be amendments to the way that the city of Chicago or Cook County approaches this. But you may be wondering if I have a business that needs to comply already with the Chicago paid sick leave ordinance, which, as we know, has been around since, I can't believe I'm saying this, but July 1 of 2017. It's been around a long time, right? And if I'm a business that has to comply with that, because I have I'm in the city of Chicago, do I need to comply with the Illinois Paid Leave for All Workers Act? And as of now, if you need to comply with the Chicago Paid Sick Leave Ordinance, that's what you still need to comply with. You don't need that trumps, if you will, this Illinois Paid Leave for All Workers Act. You should still comply with the Chicago Paid Sick Leave Ordinance. If you are in a municipality that is not opted out of the Cook County Earned Sick Leave Ordinance and you're complying with that, well, you should comply with the Cook County Earned Sick Leave Ordinance instead of this. That trumps this. Again, I want to say, as of now, stay tuned. There could be adjustments to this, okay, in both senses. If you have a restaurant in a municipality of Cook County that has opted out of the Earned Sick Leave Ordinance, then you need to comply with this Illinois Paid Leave for All Workers Act, okay? And if you have a restaurant in Illinois, which is not in Cook County or not in the city of Chicago, you need to comply with this law. So I just wanted to comment for a minute on the interplay of this new Illinois upcoming law, paid leave law, and the city of Chicago paid sick leave ordinance and the Cook County earned sick leave ordinance. So everyone, at least as things exist now, is on the same page on that. Okay, let's go to the next slide. Employers must, I'm going to just hit the high points. There's more on this. Okay. And there's hopefully there's going to be more things, but there is some FAQs. If you go online, you can pull up some FAQs on this law. I encourage you to read them, but the highlights are this. Employers must allow all full and part-time employees to earn and use up to 40 hours of paid leave during a 12-month period. Employees must be allowed to earn paid leave at a rate of at least 1 hour for every 40 hours worked. Employers have the option of instead front-loading 40 hours of leave at the beginning of the person's employment or the beginning of the new 12-month period, okay? Employers may set what the 12-month period they will use for paid leave is, whether it's going to be, a lot of times employers want it to be calendar-based because it's easier to administer. And by the way, for those entities out there that use payroll companies, you're going to want, all the payroll companies are going to want to get in sync on keeping track of this, the accruals and how much people have used and all that sort of thing, just like you've been doing for the Chicago and Cook County sick leave laws. I'm assuming that those, entities out there that use payroll companies, of course, they've been on top of that for you. It's very important. Employers must allow employees to carry over all unused paid leave at the end of the 12-month period, unless they front load paid leave. If you front load the paid leave, the carryover requirement under this new law does not apply. So that's a business decision that needs to be made. There's different factors that favor both. I've been talking to many clients about this. If you want to talk to me about it or whoever you talk to, let me know. But business decisions need to be made in this area, okay? Employers must allow employees to begin using paid leave 90 days following the beginning of their employment or 90 days following this new law, whichever's later. Employers with existing paid leave policies that provide for at least 40 hours of paid leave need not provide any more so long as employees can use the paid leave for any reason. So let's stop for a second. I've been talking extensively to clients about, hey, I already have a PTO policy in my handbook, or I already have a vacation policy in my handbook that provides for at least 40 hours of paid leave. Do I need to add more under this new law? Well, from what I just said, the answer to that is no. Okay, so long as your policy provides at least 40 hours within the requisite time frame in accordance with this new law, And so long as your policy complies with all the tangential requirements that this law puts into place, then you're good. But again, I encourage you to talk with someone who knows this law and who knows, what features need to be included in your policy. But I want to be really clear. If you have a existing vacation or PTO policy that doesn't have limitations and provides for use of vacation or PTO for, basically unlimited type reasons, okay, not just sick type reasons, and you offer at least the 48 hours of paid leave, you don't need to offer 40 more hours because this new law came into effect, okay? So that's a very important point. Employees may take paid leave for any reason, are not required to provide a reason for the leave, and do not need to submit documentation or proof to support the leave, okay? You guys are all used to this. This is even more generous to employees than the paid sick leave. I'm sorry, the paid sick leave ordinances. The paid sick leave ordinances, you can't require documentation unless, until the fourth day of an absence, okay? So at least there's an opportunity there to require documentation. Here, you can't request the documentation to support it, the leave. All right, let's go to the next slide. Employers may set increments for use of paid leave in no greater than 2 hours. Employers may set notice procedures for paid leave. If the need for paid leave is reasonably foreseeable, employers can require employees to give up to 7 days notice. If the need for paid leave is not reasonably foreseeable, employers can require employees to give notice as soon as practicable. An employer may not require an employee to find a replacement or substitute to cover for the employee's leave. Unused paid leave need not be paid out upon termination. However, any unused leave must be immediately reinstated if the employee is reemployed within 12 months from termination. However, what's the caveat here, guys? The caveat is that if you just choose to comply with this through your existing PTO, if you just do it through your PTO or your vacation, well, under Illinois law, you have to pay out unused accrued PTO or unused accrued vacation upon separation. Okay, that's standard Illinois law. All right, so keep that in mind. Okay, this really isn't that pertinent to the restaurant world because very few restaurants are unionized. But if you are one of the few restaurants that have a union contract or a collective bargaining agreement in place, at least as of now, if you have a collective bargaining agreement in place and it's going to be in effect already as of January 1, 2024, this paid leave law does not change the terms of that CBA. So you don't, you follow the CBA. However, if you don't have a CBA in place as of 1/1/24 and you're negotiating the CBA that's going to, that takes effect after 1/1/24. If you don't want to have to follow this law as a restaurant or employer, you have to get express waiver in writing in the contract from the union. Okay, so again, this doesn't pertain to many restaurants because so few are unionized, but I did want to point it out to the extent that you're in the minority group and you do have an existing collective bargaining agreement as to its impact on this new law. Let's go to the next slide. The One Day Rest in 7 Act, it's a Illinois law. It's been around a long time, but effective January 1 of 23, employees must be provided an additional 20-minute break if working a 12-hour shift or longer. For a day of rest, employees must have at least 24 consecutive hours of rest in every consecutive 7-day period. That's literal, every consecutive 7-day period. It's not defined anymore by payroll. Okay, so the 7-day period can extend across 2 different payrolls. To remind people, just as a reminder as to what the law is on meal breaks in Illinois and federal law, to make sure you're complying with both. To comply with both Illinois and federal law on meal breaks, you have to give the employee a minimum of a 20-minute paid break or a minimum of a 30-minute unpaid meal break beginning no later than the 5th hour of a shift that is 7.5 consecutive hours or more. Pertains to shifts of 7.5 consecutive hours or more. Again, I'm going to say that again. You have to provide employees a minimum of 20-minute paid or 30 minutes unpaid meal break beginning no later than the 5th hour of a 7.5 consecutive hour shift or more. And this amendment to ODRISA speaks to needing to provide an additional 20-minute break if working a 12-hour shift or longer. Okay, so if the person's not working 12-hour shifts or longer, this amendment's irrelevant, but I did want to point it out in the event that it becomes pertinent to your business. Okay, let's go to the next slide. All I want to say about this, guys, is that the penalties have been enhanced. As we've seen in a lot of different areas, including the Chicago laws in the wage and hour area, federal and state laws in the wage and hour areas, the penalties for violations of these acts have been enhanced and increased. All the more reason why you want to make sure that you understand these laws and that you're complying with these laws. Okay, let's go to the next slide. The amendment to ODRISA, I'm going to call ODRISA, it's the Illinois One-Day Rest in 7 Act, now requires that employers conspicuously post a notice in the workplace, which is provided by the Illinois Department of Labor. You can go to their website, okay? The new notice outlines employee rights under ODRISA and information on how to file a complaint. From remote employees, to the extent that you have them, I know in the restaurant world that the remote employees, if anyone, might be people that sometimes work remotely, to do your marketing or bookkeeping or things like that. Obviously, most of your workers are on site, given the type of business you have, but employers must provide the notice by email or on a website, okay? Let's go to the next slide. I showed you an example of what the poster looks like, but go to the Illinois Department of Labor website. If you have any questions, ask me, okay? Or ask whoever you would normally ask. The ODRISA, next slide, excludes certain employees. Again, not so much pertinent to the restaurant world because very few restaurants are unionized. But if you are one of those minority groups that are unionized and you have a collective bargaining agreement in place for employees covered by a collective bargaining agreement, these newest ODRISA amendments exclude those employees so long as the CBA contains a provision that specifically addresses work hours, days, work, and rest periods. It must have express language regarding meal periods and days of rest, or ODRISA will apply regardless of the employee's union status. So make sure that when you're negotiating collective bargaining agreements, or if you're using a lawyer, they're going to know this, that you want to make sure that that language is specific enough to trump, if you will, ODRISA. Okay. Next slide. Okay. Before I get into this, I want to go off the slides to say a couple things in the wage and hour area. You guys can look online. This information is all readily available when you go on to the BACP Chicago's website. When you Google what the Cook County wage rates are and the Illinois wage rates are, but let's just go through it briefly, just so we're all on the same page, and look online if you have any follow-up questions, or ask me or whoever it is you talk to. But just want to make sure everyone's on the same page that as of July 1, 2023, the Chicago minimum wage rate for employers with 21 or more workers is $15.80. For employers with 4 to 20 workers, it's $15. The new tip credit rates for the larger employer group is $9.48 for Chicago. And for the smaller employer group, it's $9 for Chicago as of 7/1/23. For the city of Chicago, as of 7/1/23, the minimum wage to be paid under city contracts or concessionaire agreements is $16.80 per hour. Effective 7/1/23 for Cook County, the minimum wage rate is $13.70 per hour and $8 for tipped employees. And for the state of Illinois, as of 1/1/23, it's $13 an hour for workers 18 and up and $10.50 for under 18 age workers. And the tip credit is $7.80 for 18 and up workers and $6.30 for workers under 18 in the state of Illinois. If you're not sure which one you have to follow, ask me or someone you would normally talk to. I'm just going to say briefly that if you're in the city of Chicago, when you're operating a restaurant there, well, which of these wage rates do you have to follow? You got to follow the city of Chicago, the highest one, the minimum wage rate. Okay. That's the way it works. All right. So just make sure that you're doing this correctly. Audit your payroll and pay stubs, even if you use reputable payroll companies. Audit it from time to time. Make sure that you're calculating overtime correctly for both, for non-exempt, both tipped and non-tipped employees. I'm not gonna get too much in the weeds on this, but one area where we see restaurants get tripped up sometimes if they don't know better is in the calculation of overtime for tipped employees. If you're not sure how that should be calculated, please ask someone that understands how that needs to be calculated. Okay, it's a very important point. People get that wrong, all right, if they don't understand it. Happy to talk with you about it. The other thing that my firm and I are, what's the word? Oh, maniacal, I guess, about, very, very sensitive to on behalf of our clients, because we want to make sure they're protected, is, you've heard me say this probably over the years, guys, tip credit notices, written tip credit notices, okay? The Fair Labor Standards Act doesn't require these to be in writing, but gosh darn, it's definitely a best practice, okay? For your tipped employees, every time that there's a change in minimum wage rate, like just recently, okay, 7/1/23, or if the person gets a change in their wage rate for whatever reason, you should be issuing new tip credit notices to these tipped employees that sets forth the arrangement, the tip credit arrangement. The language needs to be precise. We prepare these for our clients. If you're not sure what I mean, ask me or someone that understands this, but you want to keep these in people's personnel files if they're tipped employees, and they need to be modified every time that there's a change in pay. Why is this so important? When we come to defend restaurants and other companies when they're being sued for wage and hour violations, a lot of times plaintiffs' lawyers say that the restaurant or business loses the ability to take the tip credit because they didn't inform the employees correctly or appropriately that this arrangement was going to exist. And that's why you want to have that document in place to disprove that notion, okay? Let's now shift gears to the slides, the Equal Pay Act amendment. We're almost at the end of this 2-year initial period. For those employers with 100 or more employees, you need to obtain and apply for the Equal Pay registration certificate. Let's go back. I'm sorry, just let me finish quickly to that prior slide. No problem. Complying with the act, the Illinois Act, employers will receive notification if you haven't already. A lot of our clients have already received it from the Illinois Department of Labor. But however, all covered employers must apply by no later than March 24 of 2024. What we're telling, as we're, look, we still have time here. We still have about, 8 months left, okay, before this March 24, 2024 deadline. But talk to it is who you normally would talk to. But we are telling clients that as this date gets closer, if you know that you have 100 or more employees and need to comply with this requirement, reaching out to the agency to see why you haven't received the notification. Okay, a lot of our clients have already received it. We're helping our clients, comply with this, but it's a laborious task. So if you know that fairly laborious task. So if you know that you have to comply with this, don't wait to the last minute until you get this. Start compiling the data now so that you're not scrambling at the last minute to obtain the certificate, okay? When applying, employers will need wage records, including the most recent EEO-1 report, an equal pay compliance statement signed by a corporate officer. Employers are required to recertify compliance every 2 years in Illinois. If you have under 100 employees, this isn't pertinent to you, okay? So, but if you have 100 or more, it is. All right, next slide. Provide your business contact information to the IDOL, the Illinois Department of Labor, to ensure the IDOL can send you information on obtaining your equal pay certificate. I'm assuming you've done that already. If you are in the 100 or more employee camp. When your business receives its application deadline from the IDOL, prepare your application and file by the deadline. Businesses with multiple Illinois locations need only file a single application. And then I list here, what are the things that you need to submit with your application. If you have any questions about any of these things, let me know, or you can go online. And like I said, once you obtain your initial certification, you'll be required to recertify every 2 years. But a very important new requirement, like I said, we're reaching the end. I can't believe it. We have about 8 months left in that first 2-year period. Many of our clients have been already receiving these requests to submit for the certificate. But stay on top of this if you know that you're a business that's going to be required to do so if you haven't already received that invitation to submit from the government. Okay, next slide. I want to mention this. I don't want to spend a ton of time on it, but as I was preparing for this today, gosh, I'd be remiss. My firms had to put together a whole separate biometric information privacy sub-department. We're defending about 30 or 40 Biometric Information Privacy Act class actions on behalf of not only hospitality clients, but also clients in all industries. And I just don't want anyone to be blindsided by this law. It's been around a long time, but these cases, in light of the really lousy case law as it relates to employers over the years, has become a significant risk of potential liability and exposure for employers. And what I'm talking about here is, to the extent that you are a restaurant or a business, you have a business that uses a biometric means of time recording or of keeping track of entrance and exit from your business, or conceivably on your phones that you give people or other electronic devices. I'd want to talk with you more about it because it's nuanced in that area. Make sure that you're aware, if you aren't already, of this Illinois law, the Biometric Information Privacy Act law, which is extremely important. And if you're going to use biometrics, or if you do, you need to have a legally compliant Biometric Information Privacy Act policy and a consent form, both of which that are signed off by your employees for whom you use this methodology in advance of using it. And you can, but it's not sensical. You don't want to be pulling these things off the internet. You want to have, if you're going to use it, you're best served to go to a firm that understands what needs to be in these policies and these consent forms so that you have it right. The law is ever changing. And I'm going to end by saying this. If you use biometrics, okay, and again, I'd want to talk with you a little more. You should talk to whoever you would. The way the law is in Illinois, I would stop using biometrics. I've had this conversation with so many different clients. I would use a non-biometric means. Yeah, clients tell me, well, it reduces the risk of, buddies or fellow employees punching in for other employees. Well, you know what my response is? I get it. I'm not naive to the challenges that you face, but the risks of a Biometric Information Privacy Act class action dwarf that. There's other ways that you can address those other issues. And I would not want to be in a situation where at this juncture, the way the case law is, where you're exposing yourself to biometrics. So if you do use biometrics, if you're not sure if you use biometrics, if you're not sure if you fall within the ambit of the biometrics law in Illinois because of what you're doing, please talk to me or someone that understands the biometrics law so that we make sure you're protected. I can't emphasize this enough. The way we get involved in these matters, unless I learn of it because we're looking at an employer's handbook, or because they tell me, or because I ask the question when they become a new client, we get these cases to defend, you could imagine, not because businesses are bad people or because they're dumb. They aren't dumb. They're smart people. Okay, very smart. But it's because, a lot of times they just don't know about the law.
Rob? Let's give Rob a second. I think he's having some technical difficulties. We're just giving Rob a second to log back on. I think we lost him, but he's on his way back. Just a minute. If you have any questions now, feel free to submit them, and then when he returns, we'll start the Q&A portion.
Sorry. Are you there? Is everyone there?
We're here,
Teresa?
Rob. Welcome back.
Okay,
Yep.
I don't know what happened. My internet.
okay.
Okay. All right, next slide. Sorry, everyone. Next slide. Technology, right? Next slide. Let's skip all the BIPA slides. I said my piece on BIPA, but please understand. Now I want to talk about the Illinois Human Rights Act training requirement in the anti-harassment area. Old news, really. It's been around, for a little bit now, but for those businesses in Illinois, you have a requirement to provide annual sexual harassment prevention training to be completed by December 31 each year. I list here what it needs to include. You can go online, make sure that, if you're doing this on your own, we're obviously a firm like mine, we're feverishly doing this every year for all of our clients, or most of them. They want us to do it to make sure it complies. But if you're doing this on your own or some other way, make sure that the materials comply with the Illinois Human Rights Act for anti-harassment training. Next slide. And make sure that your people sign off each year that they've done it, and that you keep that in case you're audited. Now I want to talk about some notable City of Chicago legal updates. Let's go to the next slide, please. The Chicago Human Rights Ordinance on April 27th, the City Council of 22. It's old news, but I want to mention it. They passed an amendment bolstering the Chicago Human Rights Ordinance as it relates to victims of sexual harassment. The definition of sexual harassment was broadened to include sexual misconduct. Chicago Commission of Human Rights increased the statute of limitation for filing complaints from 300 days to 365 days. Penalties for violations, it's kind of a theme here, has increased significantly. All the more reason to make sure that you're buttoned up in the anti-harassment realm and you're complying. You have a legally compliant City of Chicago policy in the event that you have business in the City of Chicago. Next slide, please. Training, if you're in the City of Chicago, your training requirements are enhanced beyond what I just said for Illinois, okay? Anyone who supervises or manages has to participate annually in a minimum of 2 hours of sexual harassment prevention training and an additional 1 hour of bystander intervention training. If you're non-management, you need to do 1 hour, participate in 1 hour of sexual harassment prevention training and 1 hour of bystander intervention training. So what are we doing for our clients? My firm that's in the City of Chicago. I'm doing 3 hours of total training for managers and supervisors and 2 hours of total training for non-supervisors and managers each year. And you have to make sure that the materials comply with both the prevention and the bystander intervention training. Okay. This is for the City of Chicago. Very important. It's old news because it's in effect now, but make sure that you're doing it annually. Make sure that you keep the PowerPoints and other training materials that are used. Make sure that you make it mandatory. Make sure that you have all the people sign off on it and keep it in a file in the event that you're audited. Okay. Very important, not only from a prevention standpoint, but from a compliance standpoint, in the event that someone from the BACP shows up at your doorstep and is auditing you and making sure that you're doing this, which as time could happen more and more. Okay, next slide. And make sure, to my comment about, I get it, I'm not naive, but make sure that you have an anti-harassment policy that's compliant with the law. It should be in your employee handbook. Employees should sign off on it. It should be posted in a prominent place. You need to have a poster advising of the prohibition of sexual harassment. The model poster can be found on the city's website for the city of Chicago here. If you have people that don't understand English well, or they don't speak it well, you want to have these items translated, your policy, your handbook, the poster into Spanish or whatever language it is, whether it's Polish, Spanish, Russian, whatever it is. You get my point, that you want to be mindful of the translation piece. Let's go to the next slide. I think that's the main things I wanted to cover. There's more, but I knew we had about an hour today. The other thing I want to mention, a couple other items that I want to mention just before we stop here, and I'm happy to take any questions in the allotted time here. But the other thing that we're getting a lot of questions on are service animals. Okay, to the extent that in the summertime, you're having more and more issues where your patrons are bringing in service animals, saying that they need them to help with guide them due to a disability. And I just wanted to touch on this to make sure that that your managers and supervisors understand how to handle these issues. But one thing that comes up, I'm just going to hit on a couple points. Can you ask these patrons to show documentation proving that the animal is a service dog? And the answer to that is no, under the Americans with Disabilities Act. You can ask them, though, whether the animal is a service animal, and you can follow it up with an inquiry as to what disability the dog is trained to help with, or what work or task the dog has been trained to help with. Okay. So you can follow up with those questions. You can ask, is the dog a service animal required because of a disability? You can ask, what work or task has the dog been trained to perform? But you can't ask for documentation or require documentation that the animal is a service dog. Okay. You can ask those questions. I should be more precise, in scenarios where it's not obvious from a tag or something that the animal's already a service animal. Okay. So that's one thing. We have gotten certain complaints that have been registered, and we're helping restaurants and other places navigate that as to how restaurants have handled certain service animal requirements. So I just want you to be aware of that. The second thing I want to mention, I mentioned two things, but there's actually three. Sorry, guys, that aren't on the slides before we open it to questions. To the extent that you're a business in Evanston, I touched on this. Teresa knows this. A couple months ago, I did something similar to this in Evanston, and we touched on the Evanston Fair Work Week ordinance that's going to be going into effect in September of this year. So very soon. If you're a business in Evanston, or if you have a business in Evanston, make sure that you understand the implications of the new Evanston Fair Work Week ordinance that's going into effect September of 2023. Ask me if you have any questions about that. And then, guys, you've heard me mention this over the years so many times, but it's such an important point. I feel like I need to say it in almost every seminar. You've heard me mention employment practices liability insurance, or EPLI. To the extent that you don't have employment practices liability insurance, and you should talk with your insurance broker about this if you don't have it or you don't know what this is, or ask me, I would have a conversation with your insurance broker to discuss whether it makes sense to get EPLI. I'm not minimizing the costs, but I can tell you, just as I mentioned when I was telling you that you should have a compliant handbook with someone that knows what they're doing to get it in place for you, you should also talk with someone who understands EPLI, because I will tell you, if to the extent that you're thinking, oh, geez, I'm a small business, I have 15 employees and I don't need EPLI. A lot of times EPLI, just if you're not clear, covers wrongful termination type claims, sexual harassment type claims, claims under the Americans with Disabilities Act. Most employment law claims, except wage and hour claims, and now more and more biometric information privacy act claims are excluded. Wage and hour claims could be covered from a defense fee standpoint if you get the wage and hour rider. So a separate rider, you want to talk with your broker. But what I was saying is the need for EPLI oftentimes is greater with a small business that doesn't have the resources. If you get a really messy sexual harassment case where the person is asking for millions of dollars, well, that could implicate the very essence of your business and the viability of your business. So I can't emphasize enough. Please do me a favor. And if you want to talk about it more, let me know. But talk with your broker about employment practices liability insurance. More and more, and most of my clients have this now. Okay. And the ones that don't, you could tell by my comments here, I tell them every year to get it. Okay. You can have the best labor and employment lawyer, the best human resource professional in the world. We can't control what all our employees do. Okay. And all it takes is one rogue employee to, get you embroiled in an expensive case. So I'm going to end my remarks. Thank you so much, guys. I appreciate it. I hope these were helpful reminders. I'm here as a resource for you. Thank you very much, everyone, for your time. I'll take some questions, Teresa. And Teresa, once again,
Thank you so much, Rob. Yeah,
thank
course.
you. I
We
appreciate
have
it.
a lot of questions that came in. So I'll pose you a few. So for the Equal Pay Act, someone said we have 7 restaurants that are separate corporations that are under 100 employees. Adding up employees for the 7 restaurants, we have over 100 employees. Do we have to complete a certificate?
So I don't want to get too enmeshed in this. Do me a favor, Teresa.
Mhm.
I would want to understand their corporate structure more, because the best, most well-measured answer for this group is, I love the question, is let's look at the corporate structure or get advice from someone on it, because they could be covered if the corporate structure is such that, depending on some questions I would ask, if the total employee count exceeds 100 based on all those places. I can't answer it definitively at the moment. I would need to have some question answers about common ownership, interchange of employees, common management, common control of labor relations and human resources, among other things. Okay.
Great. Let's move on to another one. So can you confirm that the 20-minute break when working a 7.5-hour shift or longer must be paid?
It doesn't have to be paid. No, it doesn't. Let me be clear. Okay. I'll say what I said again on that point. Glad that we're asked. So you can comply with Illinois law and federal law. You need to comply with both in this area in one of 2 ways in this area. Number 1, okay, you can provide a minimum of a 20-minute paid meal break beginning no later than the 5th hour of a 7.5-hour consecutive shift or more, or a minimum of a 30-minute unpaid meal break beginning no later than the 5th hour of a 7.5-hour consecutive shift or more. Okay.
Got it. Someone said, does this 40 hours need to be taken all at once or in small parts?
For the Illinois paid leave law,
Yes.
there's 2 options under the Illinois paid leave law, and you should talk about which one you should adhere to. There's pros and cons. You can comply with by either having someone accrue an hour of paid leave for each 40 hours worked, and you keep track of that along the way, similar to what a lot of you have been doing under the paid sick leave ordinances, or you can front load and provide the full bucket of 40 hours at the beginning of their employment and at the beginning of each subsequent 12-month period. And there's consequences for both, or implications, I should say, for both. If you front load with this new Illinois paid leave law, you don't have to comply with the carryover provision. If you don't front load, you do.
Got it. Thank you. I have One last question, and then we'll end our time here. We have a handbook that everyone signed up on. However, new issues have come up, such as uniforms and facial piercings. Can our handbook be updated addressing such issues that tighten and limit facial piercings? Or would these be affected by these new rules?
So is the question just about facial piercings, Teresa?
Yes, it's not hair.
So let me answer, because the first part was a pretty broad question. So let me answer the first part. Because it's so important. If you haven't modified or updated your handbook in a while, there's so many reasons why you should now, and you should redistribute and get re-signatures on the updated handbook. Okay, so that's number one. All right. Number two, I can't answer it in a vacuum about the piercings question. I'll say this because it comes up all the time for our clients. I would need to see the way the language in the dress code and grooming policy exists now to in a well-measured, meaningful way, tell them how I think it should be worded as it relates to piercings. It's tough for me to comment unless I would see how it reads, Teresa.
So maybe we can follow up with the last of the questions after this webinar. So thank you so much, Rob. I think that's all the time we have for today. Thank you so much for your time. I'd like to thank the Cook County Small Business Source for their continued efforts to provide resources, information, and business advising to small businesses to help with their recovery. Following the conclusion of this webinar, attendees will receive an email with links to the webinar recording as well as the presentation. Thank you all so much and have a great day. Thanks again, Rob. Really appreciate you.
Thank you, Teresa. Thank you for
All right.
all you do. Thank you, everyone. Have a great day.
Bye-bye.
Bye-bye.